Ngomezulu.
Yes.
Yesterday the proceedings were adjourned to today in order for Mr. Ngomezulu to be present. He is now present. And I'll then ask any of my colleagues, my lord, to put the extent of the discussions that we had in chambers on record.
Yes, Mr. Ngomezulu. Yes.
My lord, as we have discussed that, and I've indicated that I'm getting much better, but I'm not in a position to cross-examine the witness, and I've made a request that my cross-examination should be suspended until after the cross-examination of Advocate Mshololo. I will then proceed after Advocate Mshololo, and the parties have agreed, and Advocate Ngumalo has agreed to stand in for me, and that has been communicated with my client. And this will be accused number 1 on the basis that the condition in court will actually hamper or disturb the progress of my healing as the court pleases.
Yes, Mr. Ngumalo.
Thank you, my lord. I was approached by Mr. Ngomezulu after we've met in chambers and requested me to stand in for him in order to allow him to recuperate. I have no problems, my lord. This was communicated to his client, Mr. Sibiya.
naye Advocate Ramosepele uyashoke ukuthi ngempela ke sebephumileke kuyena umehluleli Mr. Ngomezulu usizikele wamcela ke ukuthi ke ameleke ngalesikhathi yena ke esathi ke ukhulama wathi ke naye ke akanayo inkinga yalokho futhi lokho ukhulunyiwe wena Mr. Sibiya.
If there is any further thing that Mr. Sibiya would wish me to convey to Mr. Ngomezulu, I'm going to take whatever instructions and inform Mr. Ngomezulu about the developments and whatever instructions that is going to relate to me. Thank you. Thank you.
So how long is the hiatus regarding Mr. Ngomezulu's health? It's going to determine how long you assist.
The arrangement is the cross-examination is going to continue up to Advocate Mshololo, and then thereafter Mr. Ngomezulu is going to come back. It is then that stage that this arrangement is going to cease.
Okay. You confirm that, Mr. Ngomezulu? Yeah, you don't have to stand up. You can just...
I do confirm.
You do confirm it. And you say this has been conveyed to Mr. Sibiya, and it was discussed in Mr. Sibiya's presence, meaning you, Mr. Ngomezulu, and Mr. Sibiya, minimum, and the other councils.
Yes, the minimum was 3, myself, Mr. Ngomezulu, and Mr. Sibiya.
Okay, and what was Mr. Sibiya's view?
He agreed to the arrangement. May the court confirm also from him.
Mr. Ramosepele?
As the court pleases, my lord, I do confirm the arrangement, and I do also confirm that as part of the part discussion, I was involved, my lord, as the court pleases.
Mr. Nisi?
As it is the court, my lord, although I was not involved in the discussion, but I'm quite happy with the arrangement.
Okay.
Thank you.
Mr. Munyeki, sorry.
Yes, my lord. Yeah, my lord, I was not part of the discussion, but I do confirm that some of the issues were raised with the defense of accused number 5.
Mr. Sibiya, stand up. Do you confirm the agreement, the arrangement?
Yes, I do confirm, my lord.
Okay. Yeah. I'm just going to quote what the law says.
Yes, Malo, can I just maybe add something?
Oh, yes, Mr. Sorry.
Regarding the ambit of the discussions that we had in chambers.
Yeah.
It was emphasized that Mr. Mgomezulu will follow the proceedings as they occur, and will also get a running record of the proceedings, so that he's fully acquainted with what is happening in court.
Yeah, how does he follow the proceedings?
Yes. Well, the proceedings have been broadcast live, my lord, and
Okay.
he will, and I don't want to speak on his behalf, but I think the extent of the discussions was that, he will follow the proceedings in whichever way to acquaint himself of what is going on. And I suppose if there's anything, he will then communicate with Mr. Ngumalo. And the other thing, my lord, that I'm wondering about, should he then recover before the end of the cross-examination of Mr. Ngumalo, I suppose then he should come back to court. So he's excused from court pending his recuperation or the finalization of the cross-examination by Ms. Mshololo, whichever comes first. That should be the condition.
Thanks. Is that your understanding, Mr. Mgomezulu?
Whichever comes first, my lord.
Okay. Yeah, but that you are going to follow the proceedings on YouTube, you said the other day.
I've been following it, man.
Well, they've got problems with YouTube
No problem.
because there are too many experts there.
Huh?
Yes, sir.
On that aspect, the proceedings from the 7th of October to the 22nd of October 2014 were emailed to Mr. Mgomezulu, and he confirmed yesterday that he received my emails.
Yes.
So whatever that comes from now on, I will be forwarding whatever that comes to Mr. Mgomezulu in order for him to apprise himself with the proceedings. Thank you.
Yeah. Okay. This is what the law stipulates. The cross-examination. Let's start the cross-examination sequence, which appertains in a court of law, is governed, I think, by Section 127. And amongst others, it is discretional upon the presiding officer as to the sequential cross-examination which is going to be exercised by various counsel in a particular case like this one, has to abide by the prescripts as to how the accused before court are being cited after being charged. In other words, lack of a better word, if Mr. Sibia, as he is accused number one, his counsel is expected after each and every witness to be the first to cross-examine the state witness who has given that evidence. But these procedures are not immutable. They are not cast in stone. They can be modified, added to, if special circumstances arise, like in this case. This case started before this court in July 2023, but previously my colleague was involved in this case, Judge Maumela, who had to recuse himself after being incapacitated physically. So I am aware that the allegations also arise against the accused as on during October 2014, about 10 years ago. This court will not go into the history of this trial, but for various reasons, the actual concourse of this trial only began, I think, in 2019, is that so? 2019, before Mr. Maumela.
Yeah, well, before Judge Momela, it was the first appearance was
Yeah.
in February 2022.
Okay, yeah, right.
Yes.
So that was the initial appearance of the accused before this court. So I am of the view that because of the history of this case and because of the incapacity, which I believe is temporary, of Mr. Mngomezulu, these aspects constitute special extraordinary circumstances which may allow this court to accede to the request by Mr. Mngomezulu and his client that Mr. Mngomezulu will keep himself apprised of the proceedings in this case, as he has always been doing, and he will keep in contact with Advocate Ramosepele, who has volunteered to assist accused number 1 and Mr. Mngomezulu. The overriding aspect is that no other accused should suffer prejudice in this trial as a result of the arrangements which this court is agreeing to as requested by Mr. Mngomezulu and his client. Because the court is enjoined in terms of Section 35 of the Constitution to accord an accused and his counsel or attorney a fair trial as described in our Constitution by, amongst others, a retired judge of the Constitutional Court, Johan Krichler, in the case of the Attorney General of the Cape versus Key, which is a constitutional case which is seminal, in my view, in defining the aspects which we all refer to as a fair trial. And I'm also consoled by the fact that there is no apparent conflict of interest amongst the accused and their counsels regarding the charges facing the accused. The accused are facing 5 charges. Murder with the application of Section 51(1) of the Criminal Procedure Act. Robbery, also with the applicability of Section 51(1). Possession of a firearm, and also attempted murder with the applicable Section 51(1) also being there, and possession of ammunition. And further, the accused are also charged jointly with the allegation that they allegedly committed these offenses in pursuance of a common purpose. So consequently, the onus of proof, which rests on the state to prove its case beyond a reasonable doubt, is not delineated differently from either of the accused. The state has to prove those charges with the application of the doctrine of common purpose. All 5 accused also reserved their right in terms of Section 35 of the Constitution not to disclose the basis of their defense. Consequently, as I say, up to this stage, it cannot be cogently argued that the accused, any of the accused or counsel, with regard to the arrangements which this court is acceding to about the health of Mr. Mngomezulu, that there has been a conflict of interest or there has been a denial of the concept of a free trial which must appertain to all the accused before court. Consequently, then, that application is granted. As also, he gets a periodic record of the proceedings, besides just himself being apprised of the progress of the trial, he must also be furnished, as he has been furnished by the running record, which is available to all counsels in this case. And therefore, I find that it is in the interest of justice that this case should proceed. Okay, yes.
Yes, my lord.
Yes.
I have excuse.
Thanks. Mr. Brigadier.
Yes, my lord.
Gininda, you're still under oath. Okay.
Yes, my lord.
Thanks. Okay.
As the court pleases, my lord. My lord, may I proceed?
Yes.
Thank you. Morning, Brigadier.
Morning, Mr. Ramosepele.
Now, sir, I'm going to start my cross-examination with certain preliminary questions before we address exhibits HH and JJ, which are the confession statements of accused number 2.
Yes.
Now, in your evidence in chief, you testified that you were tasked by Lieutenant General Nkomo, who was at the time the head of detectives, for you and certain members of the police to visit the family of the deceased, being Senzo Meyiwa, in October 2016. Is that correct?
I don't remember the month, but yes, around 2016, my lord, that is correct.
Perhaps to refresh your mind, do you recall if you made a statement to that effect?
Yes, I did, my lord.
Brigadier, I'm going to refer you to A128, which is your statement, and your handwriting is like mine. It's like a doctor's handwriting, so I'm going to ask you to personally read it. My lord, the statement is A128. It's a statement by Brigadier Gininda. I don't think it's complete, my lord. Let me look for the part. Yes, what, A128. My lord, let me pack this question. I see the A128 that I have does not have the commissioning part and the other paragraphs. I'll ask the state to assist me in this regard. But you have indeed made a statement regarding this visit to the family of the deceased.
That is correct, my lord, and I do have the original A128, and indeed it does indicate that it was around October 2016. So I have
Okay,
the original
if you go to
statement.
the back of it, then just tell the court when it was commissioned and by whom.
It was commissioned in 2019, November the 29th, by Sergeant Mohola, my lord.
And I'm going to request you, Colonel, with leave of the court, to place the contents of that statement in record.
So it reads as follows, my lord. I, the undersigned Bongani Nicholas Gininda, state under oath in English as follows. I'm a police officer with personal number there's a personal number, my lord, holding a rank of a colonel and stationed at the National Head Office, NATCOM's office. Then I've placed the cell phone number. Paragraph 2, on the 27th October 2016, I was tasked by then Divisional Commissioner of Detectives, Lieutenant General Nkomo, to assist with the visit of the Senzo Meyiwa family in KZN. She further requested me, I think, with my team to assist in the investigation of the said matter of the death of Senzo Meyiwa under Phosphorus 636-10-2014. It is prudent to mention that I was not part of the investigation of the said matter when it initially occurred in 2014. I was tasked by the Divisional Commissioner together with the following members: Lieutenant Colonel Ramohala, Captain Mabuti, Sergeant Mohane, and 4 tactical team support members. I wrote Sisiane, Ngwenya, Fusi, and Swahili. On the said date of the 27th of October 2016, we indeed arrived at Senzo Meyiwa's place, where we met his family We introduced ourselves and advised the family that we will be assisting with the investigation of the said matter in question. The family indicated to us that the son-in-law, Mr. Thope, has knowledge or information that can help us with the direction of the case. We were given the contact numbers of the son-in-law, and I phoned the son-in-law from my cell phone to arrange for us to meet. Mr. Thope agreed to meet us on the very same day in Wimpy, next to his place of employment in Devon area. We met Mr. Thope where we identify ourselves. Mr. Thope was specifically interviewed by Captain Mabuti in my presence, and his statement written down by Captain Mabuti, where Mr. Thope then took an oath and signed it after the statement was written. It was given to me, and I inserted it on the investigation file where I marked it on top with my handwriting. The said statement was never removed by me at any stage until the case docket was given by my team to Colonel Shibiri for further investigation. When I was reappointed by the current Minister and the National Commissioner to revisit the said investigation, the said statement was still in the docket when the dockets were given to us by the previous investigation team. Copies of the docket was given to 4 members of the investigation team. This means Lieutenant Colonel Buthelezi, Lieutenant Colonel Ramohala, Warrant Officer Makubo, and later Advocate Ramosepele from DPP KZN. After this said docket were given to These said dockets were given to the DPP Johannesburg for further guidance. The said statement was in all material times in the docket, and when the dockets were given back to me as the lead IO from DPP, the said statement was in the docket and is still in the said docket to date as A116 and A175 correct indexing. After the interview with Mr. Thope in October 2016, I have never phoned or spoken or met Mr. Thope for any reason to date. I have never taken or written a statement from him directly with my own handwriting or said in any interview other than what is listed above. Then it's the oath, my lord, and where I then signed, then is the commissioning.
Thank you, Brigadier. As the court pleases. Now, Brigadier, you state that at the time you were not part of the investigation of Fosloras 636, 10 of 2014. Who was the investigating officer at the time?
Brigadier Modise, the late Brigadier Modise, my lord. He was from Gauteng.
And the gist of your A128 is that Mr. Thope then made a statement which was obtained by Captain Mabuti. Is that correct?
That is correct, my lord. But furthermore, my lord, that the said statement made or taken from Mr. Thope is in the docket, because 128 was in relation to the allegation or the assertion that the statement that was given by Mr. Thope in my presence, although it was said it was taken by me, is missing. So the gist of 128 was to correct the allegation, to say the statement was taken in my presence by Captain Mabuti and the statement is not missing, it's still available.
And where were those allegations that the statement has now gone missing from the docket? Where did those allegations emanate from?
Well, my lord, it came up when so you'll see the date, my lord. It's 2019 when it was commissioned. So one will see that in 2016 I didn't make a statement myself because there was no need, there was no allegation. I was basically present when the statement is taken from Mr. Thope. Fast-tracking to 2018, I then get appointed as the lead investigating officer. We then, while we were running with this investigation, then these allegations, they were in the media platform, my lord. In our discussion with the NPA, because I did say that there was a prosecutorial arrangement between us and the NPA, this assertion then needed to be addressed, and that is how the statement was made. Not that someone confronted me, it was something that the DPP felt that, look, there is this issue, let's just address it, and that's how I made the statement, my lord. Furthermore, my lord, so sorry, Mr. Ramosepele, furthermore, when
and I testify about this, my lord, when docket 375 was eventually then disclosed, when I said, I think I covered that in evidence in chief, with regard to docket 375 of 1/2019, and we had to make the copies for the defense. I saw also a statement there by one of the investigators making the same assertion, insinuating that the statement taken by Mr. Thope is missing. It's something to that effect, and that basically corrects that cannot be true.
Now, Colonel, Brigadier, if you know, prior to Modise, I don't know her title that you mentioned, that she was the investigating officer of this case. Prior to her, do you know if the case was investigated by another investigative team?
Yes, so my understanding, and that is now in relation of what the docket contains, my lord. The first investigating officer that was leading was in 2014. So first it was the DPCI. That is why one will see that when the cell phones were taken from the people who were inside the house, the person who took control of those cell phones as an investigating officer is one Lieutenant Kenneth Nittling. He is from the DPCI, that's the Hawks. Secondly, the downloadings of the cell phones were done by Captain Mushwana. He is from the Hawks. The application for Section 205 for everyone that was in the house, my lord, were done by Captain Bomsrang. He is also from DPCI, the Hawks. Captain Bomsrang. He's a Lieutenant Colonel now, Lieutenant Colonel Bomsrang.
Uma kwenziwa-ke isicelo sama-Section 205-ke senziwa-ke uCaptain Bomsrang, kodwa-ke manje use-uKennedy-ke naye ubuya kuma-Hawks.
Now, in few days from there, my lord, then the detectives, provincial detectives, then took over, and then female Captain Mutetwa was then the IO of this matter. That's female Colonel Mutetwa. So Captain Mutetwa, my lord, was also working in the same office or provincial office where Brigadier Modise was. He was a colonel at the time, and there was also Brigadier Ndlovu. So it was the same office, and I'm not sure at what stage who was playing at what role at the time, but I know Captain Mutetwa was the lead IO. At the time when I was tasked by the DIVCOM, I know it specifically is Brigadier Modise, because when we got to Mr. Matala to follow this assertion by Mr. Thope that he told him what is contained in that statement, I was referred to Brigadier Modise to say, we don't know you, this is the IO, and I had to ask him to say, look, we have the request from the DIVCOM, can you allow this person to respond? And I've indicated, my lord, that there was resistance. So that is how I know the presence of Brigadier Modise. Lastly, my lord, I further know that there was a time when the provincial detectives were working hand in glove with DPCI, and I saw that in the docket. All this I'm referring to the docket, my lord, because there was a time where Major General Mukotedi was participating, I don't know whether it was a reconstruction or some form of activities with the provincial detectives. So there was also that joint type of an investigation team.
Now, your further testimony is that your team, where now you assist with the matter, this occurred on the 12th of November 2018, is that correct?
That's correct, my lord. That's when I signed for the docket after being appointed by the previous national commissioner, General Stolen.
And that the officers that were tasked with you were three more, that is Ramohala, Colonel Buthelezi, Warrant Officer Makubo, and yourself. So there were four of you. That's correct?
It was four of us, that's correct, my lord, in a sense that was the specific members, but the cold case unit, which was under my control, my lord, was tasked, in other words, handling this matter. Colonel Ramohala was part of the cold case unit. It is these two members who were seconded to the unit to assist specifically in this investigation, but the unit itself, which didn't have many members, I think it was myself, Colonel Ramohala, Sergeant Mohane, Sergeant Mohula, I think we're 4 or 5, my lord. So we're tasked to lead that. So all the resources or equipments that were needed were coming from that. But second to that, it was then these two members who were then said must work specifically with the case of Senzo Meyiwa, my lord. But to put it into correct context, my lord, the communication during that appointment referred to the four of us, meaning myself, Colonel Ramohala, Warrant Officer Makubo, and Lieutenant Colonel Buthelezi.
And as you now state, as you had previously stated, Warrant Officer Makubo is seconded from DPCI, and Colonel Buthelezi is seconded from the psychology unit of the SAPS based in Pretoria. Is that correct?
That is correct, my lord.
And thereafter, as one of the leading investigators, you then make a conscious decision that all four leading members, I'm not speaking about Mohani Mohola and the others, yourself, Buthelezi, Warrant Officer Makubo, and Captain Ramohala must be availed with copies of 63610 for bouncing of idea purposes regarding the direction of the case, correct?
That is partly correct, my lord. It's correct in the sense of the last part which talks to bouncing of the ideas insofar as what the docket tells us making the copies. That is correct. But the first assertion that the 4 of us were lead investigating officers, it's incorrect. The mandate was very clear and the ranking structure was also very clear. I was the most senior person at that time. I was a full colonel. There was no full colonel in that structure. I was the most senior person and I was appointed as such as the lead investigating officers. These other 3 members were part of the investigation team in terms of the listing, but not as lead investigating officers, my lord.
Okay, I accept that correction that you were the main lead investigator. And your testimony further is that during the course of discussions amongst the investigative team, it became quite clear that there were differences of opinion between, on the one hand, yourself, Ramohala, agreeing, and on the other hand, Warrant Officer Makubo and Colonel Buthelezi disagreeing. Is that correct?
Yes, it became very clear, my lord.
And the differences of opinion, according to your testimony, were regarding the theory of the case, namely the theory whether or not there were intruders in the house, if there were intruders or if there were no intruders. You and Ramohala believing that there were intruders, and Warrant Officer Buthelezi, Makubo, and Colonel Buthelezi disagreeing, saying there were no intruders. Is that correct?
It is correct, my lord, but it later became clear when, like I said, when I read 375, the docket 375, that there was also, as I said, a statement that seems to, not seem, it says that the statement given to Mr. Thorpe or taken by me is actually not in the docket. And the assertion that was given, and which I think that's where these allegations were coming from, it was to an extent that it was creating an impression that Mr. Thorpe gave a statement that would have been a breakthrough in this matter. And that statement somehow was not filed in the docket by me. And that assertion, and I think that at that time, obviously I was not aware of what is contained at docket. It was not even open, but subsequently it was open, and I saw that. So I don't know where it's coming from a lot, but it was there. But it also related the wage, because there was this suspicion where I was not confronted to say, but Colonel, there's a belief that you took a statement. Where's the statement? So there was that. I'm saying in addition to it, my lord, it was in the background, but later then I came to know that this is there. But yes, there were difference of opinion, and those opinions, those difference of opinion were in existence right up to the 29th when we had that meeting at the DPP's office, the 29th of January 2019. With the team, meaning Warrant Officer Makubo, Lieutenant Colonel Buthelezi, under the lead of Brigadier Perumal. It was clear that Brigadier Perumal was saying insofar as docket 636 of 10/2014, we are still investigating. I remember that the 2 members in that meeting to the DPP, their assertion was that insofar as that docket, which, like I said, my lord, I saw the file, they were saying the investigation is concluded and, they want a decision. So that was just a confirmation that there was really difference of opinion, even the approach to this.
And you stated that as a result of the differences, Warrant Officer Makubo and Colonel Buthelezi then went their separate ways. Were they then removed officially from the investigation of 636 of 10/2014?
My lord, they went their separate ways. I wouldn't say, I was the lead investigating officer, so at no stage did I say to them they should not form part of the team. It just happened, my lord, that they were not coming through, there were no reports coming. It was clear that there were a lot of trust issues, my lord. So they just went a separate way, my lord. So sorry, my lord, just to add on that, this is the reason why I said in my evidence in chief, the appointment of Brigadier Perumal was then brought in. The purpose was to be the coordinator between the SAPS and the NPA, but most importantly, it was for him to come with fresh pairs of eyes to look into this docket 636 as well as the 375, because it was in existence at the time, and then brief the National Commissioner in terms of these differences that were apparent. I gave Brigadier Perumal this docket. That is actually the only time also where the docket was out of my hand, when he made copies of this. I do know, my lord, as I've said in evidence in chief, that he didn't manage to get hold of the docket 375. There was resistance and he never got it. So, sorry, my lord, just to add on that, this is the reason why I said in my evidence in chief, the appointment of Brigadier Perumal was then brought in. The purpose was to be the coordinator between the SAPS and the NPA, but most importantly, it was for him to come with fresh pairs of eyes to look into this docket 636 as well as the 375 because it was in existence at the time, and then brief the National Commissioner in terms of these differences that were apparent. I gave Brigadier Perumal this docket. That is actually the only time also where the docket was out of my hand, when he made copies of this. I do know, my lord, as I've said in evidence in chief, that he didn't manage to get hold of the docket 375. There was resistance and he never got it. So, my lord, just to qualify, when I say it's the only time the docket was out of my hand, I'm referring other than the times when it went to the DPP, both in Johannesburg and here in Pretoria.
Now that, and emanating from your answer as to Warrant Officer Makubo, Colonel Buthelezi not reporting back to you as the investigating officer, and the fact that they do have copies of 636 each on them, does that mean there was a parallel investigation by yourself and Makubo and Buthelezi and yourself and Ramohala and Buthelezi and Makubo on this matter?
I wouldn't say there was a parallel investigation. My lord, as I said, the lines of engagement, and that is the protocol, because I was not told officially there's a parallel investigation. When an instruction is given that this is the lead investigating officer, that is instruction. Protocol must be observed. That is now the discipline that we are taught in the police. Secondly, the chain of command in terms of seniority was very clear as to who is the leading investigating officer other than the appointment itself. So there is no parallel investigation that I'm aware of. That's to answer Mr. Ramosepele's question. Secondly, there is only one docket, my lord, that relates to the death of Senzo Meyiwa, and that is docket 636, Phosphorus 636 of 10/2014. What I know insofar as what could be termed parallel, and I don't know how, my lord, is that docket 375 of 1/2019 was then opened, and I've heard this assertion that is parallel, but as I said in my evidence in chief, that is a docket of defeating the end of justice, not murder. So I'm not sure how the two can be parallel, because this is murder, this is defeating. This occurs in 2014, the docket of defeating gets opened in 2019. So I'm not aware, my lord. I know that there's been this talk that parallel, but there's no parallel insofar as I know, my lord.
You further stated that Makubo and Buthelezi are the current investigators of 37501 of 2019.
Yes, my lord, insofar as I know, correct.
And further that the A1, the complainant in 37501 2019, according to the information you have, is Warrant Officer Makubo.
Yes, I said, my lord, specifically according to the system, in other words, the case system of the police, it indicates that it's Warrant Officer Makubo, my lord.
And now, having had access to 37501 2019, and by access I'm not saying perusal, I mean the time when you had it, when an order was made that disclosure of that docket should be made available to the defense team in this matter. If you can answer it, you can. If you can't, you can't. Do you know who the suspects are in 37501 of 2019?
My lord, my recollection, and I say this under correction, my recollection, because I want to assist as far as I can, I do know that it will be the people who were inside the house, according to what they allege, and I think Mrs. I don't know whether it's a Miss or Mrs. Piri. That's basically what I recall, my lord.
Now, at that meeting of the 29th of January 2019, with Brigadier Perumal, the DPP, and yourselves as the investigative team of 636 of 10/2014, what reasons did Makubo and Buthelezi give for refusing to share that docket with a person appointed by the National Commissioner to come and coordinate 636 of 10 of 2014?
Yeah, my lord, I do not have a clear verbatim in terms of the response, but all I can say is that there was resistance. It should be noted, my lord, like I said, before this meeting of the 29th of January, there was already an engagement telephonically between the Brigadier Perumal and the members, and I was told that there was resistance. So meeting there with the DPP and them, things were not really it was a tense situation. Like I said, the Brigadier took exception in terms of protocol and discipline, but there were a lot of issues, my lord, which I don't think are relevant for this matter, except to say there was a tension, my lord, and I don't recall the reasons given, my lord.
And that infighting, that those differences between yourself, Ramohala, Buthelezi, Makubo, what effect, if any, did it have on the adequacy of investigation and the integrity of investigation of 636-10 of 2014?
Well, my lord, I wouldn't say it had any negative effect. One will recall, my lord, that, as I said, at the beginning, it was a fact-finding type of a mission. It wasn't, the misunderstanding or the difference of opinion was not insofar as whether there is evidence to link, for example, accused 1 or accused 2 or any of these accused. It was really to dissect and see whether the docket, in terms of what is contained in the docket, not what someone is wishing, my lord, or what allegations are saying, whether the docket, in terms of the evidence contained in the docket, suggests indeed that there were no intruders or there were intruders. So the difference of opinion was insofar as that part, and that is where we walked our separate ways, my lord. So insofar as the investigations that led to the site of these accused and eventually their arrest and the processes that followed, my lord, there was no issues or integrity or even a desire to say we simply followed. And I'm talking about me now, my lord, because I was now leading the team without the 2 members. We simply followed the evidence and were guided by what was available at the time. We collected whatever we needed to collect, my lord, within the prescript of the law. So there was nothing that was done out of those boundaries.
Just a moment. Now, just reverting to docket 375 of 01-2019, I know that it's got nothing to do with you, but the question is this. Are you aware that the DPP has yet to take or make a decision on whether or not to prosecute that docket?
As a please, my lord, I don't think that is correct. There is a letter to that effect. The DPP has made the decision, and his decision is to hold over a final decision pending the outcome of this matter.
Yes. As a court pleases, my lord, I do take the response by my learned colleague. If I may, for contextual purposes, my lord, refer the witness to Exhibit Q, which is a directive or correspondence from the DPP dated the 26th of October 2022, and this correspondence was addressed to the erstwhile advocate of all the accused persons before court, Advocate M.D. Tefo, and this is an exhibit of this court, my lord, and I'm not sure whether the contents thereof have been placed on record, but in line with Mafaledi's case, my lord, I'll do so here. And it reads, the addressee, like I say, it's Advocate Tefo, and the CC, this Mr. Toban, who was the instructing attorney in this matter. And it says, dear sir, Ray Foslora's case 375 of 01-2019, S versus Sibia and 4 others, CC 67 of 2020. Paragraph 1 thereof, it reads, the National Director of Public Prosecutions has issued an amended directive on the 22nd of October 2020, August 2022, in terms of Section 22, subsection 3 of the National Prosecuting Authority Act 32 of 1998, read with Section 111 of the Criminal Procedure Act 51 of 1977, and also transferring jurisdiction in respect of Foslora's case 375 of 01-2019 from the area of jurisdiction of the Director of Public Prosecutions, Johannesburg, to the area of jurisdiction of the Director of Public Prosecutions, Gauteng Division, Pretoria. The amended directive will be handed up in court. Paragraph 2 thereof. This office is therefore mandated to make a decision in respect of Foslora's case 375 of 01-2019. Paragraph 3 thereof. In the light of the fact that the decision in Foslo Raskas 375 of 01-2019 depends on the credibility findings by the trial court in the current trial involving Foslo Raskas 63610 of 2014. I have therefore decided that the decision in Foslo Raskas 375 of 01-2019 will be made at the conclusion of the current trial. It is thus signed by the DPP of Pretoria, Gauteng Division, Mr. S. Mzinyati.
Yes, my lord, I'm aware of this letter.
My lord, just to correct myself, Advocate Tefo at the time represented only accused 1 to 4, not all of them, my lord.
Is a court, please, my lord. Just a correction. Exhibit Q, it's a letter addressed to Advocate Mshololo. It's exactly the same letter, but it is a letter addressed to Advocate Mshololo. This one addressed to Mr. Tefo was not handed up as an exhibit.
Sorry, my lord, because the one that I have, and it may have been an error on my part, it's the one that's addressed to Advocate Tefo. I do not have the one that was addressed to Advocate Mshololo, but the essence is that the contents are the same, my lord.
Yeah.
They mirror each other, my lord, to the T. Now, the point that I was emphasizing was that this decision in respect of 375, for the people that you say are the people that were in the house essentially, including Maggie Piri, will be made based on the credibility findings made by this court in this matter regarding 375.
Correct, my lord, but it is insofar as the charge of defeating the end of justice, not the murder of Senzo, because the docket is very clear. It's defeating charge, my lord.
Yes. If I may get an opportunity to get my bearings on my notes. Okay. Now, before I go to the reasons, because during your evidence in chief, you mentioned several reasons why you say that you and Ramohala believe that there were intruders in the house on the 26th of October 2014 that perpetrated the offense that occurred there, correct?
Well, partly correct, my lord, in that the reasons I give in, those were my reasons. Yes. I analyzed, like I've said, everyone was given an opportunity to read the document independently. So Ramohala's views come in the sense that he was also of the view that there were people who came into the house, but I did not put it in the context that, my lord, this is what he found, the way I found it. I was simply putting my reasons to say, what is it that convinced me that they were intruders?
Now, you testified that before coming to this belief that there were intruders, your initial belief as well was that there were no intruders. Am I quoting you correctly?
Yes, you're quoting me correct, but I also qualified it, my lord, I think when I was asked by Advocate Baloyi as to where was it coming from, and I said, basically from what I was briefed, it was not based on facts, it was not factual. When I read the docket, that's when I was able to make a decision based on the facts that were contained on the docket, my lord.
And to that extent, I'm not talking about this belief from your part, initially, that there were no intruders. You made a statement to that effect, is that correct?
I don't think I made a statement, my lord. Right. I think if Mr. Ramosepele said I made one, he can tell me. I don't recall. It was just a thought, like I said, when then, I don't have a recollection of that statement, my lord.
Right. To be fair to you, the statement is not explicit to state that there were no intruders, but you deposed to a statement on the 19th of November 2020 at the NATCOM National Commissioner's Pretoria office. The statement was commissioned by Dowelani Dion Molauzi, who's a detective sergeant, and yes, it was it was commissioned on the 23rd of November 2020 at 15:30 in the afternoon.
My lord, if it was made in November 2020, I doubt very much if I would have said or created an insinuation that there were no intruders, because if one looks at that date, the matter was already enrolled. In other words, this matter was enrolled on the 26th of October 2020. My recollection, and I think Mr. Ramosepele can refer me to the index number, I'll get to that statement, but I have an idea what he's talking about. The statement I made in November, my lord, relates to further investigation and the evidence I collected insofar as my request in pursuance, or rather my application to have Kelly Khumalo charged. I think that is the statement. It pertains to that because I talked to the evidence that I've collected. What is it that I think implicates her in addition to the confessions? And I think I'll talk to the issues of the numbers that were not disclosed. So that statement that I made in November, it is insofar as the application to the DPP to say Ms. Kelly Khumalo should be charged, as he acted as a trigger point. That's my recollection. I don't think I would have said there were no intruders, my lord. Yes, my lord. So in November, my lord, if I can just assist the court, in November, there's a statement I made on the 20th of November 2020, and in no way would I say there were no intruders. And then the next one, like I said, unless Mr. Ramosepele can specifically refer me to it, the next one in November.
The one that I referred to, and let me give you the date and then just give a bit of a background of my understanding, but I want us to go to this statement.
Yes, what is the index number, Mr. Ramosepele?
I don't know what the index number is. On top it says 8225.
Yes, that's the one I have in front of me, with five pages.
It's got, now the one that I have is got 4 pages.
No, 8225, it's 5 pages. So you have 1 or 5, it goes.
Mine has got 4 pages and the paragraphs, 1, 2, 3, 4, and the paragraphs are sequential until the end, so it cannot be that one.
Is it with 5 paragraphs?
Yeah, it's a big paragraphs, 5 paragraphs.
Yes, that's the one that I have, and that's the evidence. But let me hear you, Mr. Ramosepele. Yes, but I have it.
Just hear me out, and
yes.
And you are indeed correct. Let me give you that regarding the context within which this statement was made. That it was in relation to an application for a Section 43 application, CPA, J50 warrant of arrest in respect of Ms. Kelly Khumalo. But
yes.
I want to go through this with you and put certain questions to you.
Yes.
And this one, because it's typed out, I can read myself. My
yes.
lord, I've already put the commissioning part on record that it was commissioned by Detective Sergeant Mulaudzi, but mine is dated differently, my lord. It's dated the 19th of November 2020 at 1500, and the commissioning happens on the 23rd of November 2020 at 1530. And with leave of the court, my lord, may I read this statement on record. Paragraph 1 thereof, it states, I am employed as a police officer in terms of Section 30 of the South African Police Service Act 68 of 1995. I perform my duties under the same act. I am currently stationed at the National Commissioner's Office as the commander of the cold case unit of the National Commissioner with rank of Colonel and service number with telephone number. I'm the leading investigating officer of Foslo Raskas 636 of 10/2014, which is a murder case where one Senzo Meyiwa was shot and killed on the 26th of October 2014 between 20:30 and 2100. The deceased was shot at the house belonging to his girlfriend, namely Kelly Khumalo. It initially appeared that it was a robbery gone wrong. Witness statements under oath indicated that the 2 black males entered the house demanding cell phones and money, purporting to be a house robbery. 7 adults and 1 child were present in the house when the accused entered. The witness stated that one of the accused was carrying a firearm, purporting to be a revolver. This accused was described as a black male with big eyes, dreadlocks, wearing a khaki or brown jacket or top and a hat. He was shorter in height than the second suspect. The second suspect was described as tall, slender, neatly shaven, and dark in complexion. It is stated under oath that during the robbery in the said house, a struggle ensued between Senzo Meyiwa, the deceased, and the suspect carrying the firearm. 2 shots were fired by the suspect. One of the gun shots hit the deceased Senzo Meyiwa on close range in his chest and exited at the back of his body. The second accused focused on the rest of the witnesses, and in the process, one cellular phone belonging to Ms. Kelly Khumalo was robbed by the suspects during the committal of the offense. It is also stated under oath that suspicious suspects wearing specific clothing, amongst others a hoodie, were standing hidden but only a few meters from the crime scene prior to the incident, appearing to be typing on their cell phones. It is stated that the suspect fled on foot and a hat which was worn by the shooter was left on the crime scene. It is equally stated that the suspects hidden away, which is explained to be linked to the offense, were seen running away from the crime scene. Identity kits were compiled through witnesses of these suspects. The victim was rushed to the hospital by the witnesses who were in the house. However, he was declared dead on arrival at the hospital. The incident took place between 2030 and 2100. The deceased was declared dead on arrival at the hospital at 2115. Paragraph 3. Investigations revealed that the cell phone which was robbed was picked up through cell phone towers until signal was lost, covering the area of Foslora's hostel. The cell phone was never recovered to date or ever switched on again. The evidence explained herein under would indicate that the planning of the offense and gathering after the incident took place at Foslora's hostel. Investigation which resulted in evidence under oath revealed that the victim was murdered as a contractual assassination or hit rather than a robbery or a robbery gone wrong. Evidence under oath revealed that 6 suspects actively participated in the planning and execution of the contractual murder of Senzo Meyiwa at the directive of Kelly Khumalo. This suspect, in brackets, Nonhlanhla Kelly Khumalo, is first linked by means of confessions that were made by both accused number 1 and 2, as they both implicate her as the person that gave the instructions to kill Senzo Meyiwa. Investigations further revealed that she had 4 other cell numbers that she did not disclose to the police when these incidents took place. The numbers are as follows: 079 bullet point number 1, 079 494 8773. Bullet point number 2, 073 451 5017. Bullet point number 3, 073 388 6730. And the last bullet point, 061 456 2104. Investigations further revealed that she is linked to the actual perpetrators of this murder by means of cell phone linkages. These linkages connect her to accused 3 and 5. It was further discovered that through cell phone analysis that her cell phone memory has the same photo of a see-through bag containing cash notes, and in the exact position, location, and spot as the one of accused 3. Longwetwala has the same bag of money. There is no reasonable explanation as to why Kelly Khumalo will be in contact telephonically with hitmen of her boyfriend. There is also communication records between her and her sister shows that as early as 2013, she wanted to get rid of the deceased, as she puts it clearly on the WhatsApp messages. It is abundantly clear that she hated him and wanted to get rid of him. She further states that she regrets not succeeding to get rid of him before. Taking into account all of these facts, an inference can be drawn that she meant killing him. Paragraph 4. Evidence by means of sworn corroborating and independent witness statements, establish a causal link between the offenders and the offenses of murder, robbery with aggravating circumstances, possession of unlicensed firearms, and the unlawful possession of ammunition and conspiracy to commit murder. Ms. Kelly Kumalo seems to be the trigger point of this offense. I hereby apply for the warrant of arrest for Nonhlanhla Kelly Kumalo on charges of conspiracy to commit murder and murder. Paragraph 5 is the taking of the oath. It is not signed by yourself and commissioned by the commissioner who I have mentioned before, Detective Sergeant Mulawuti.
Yes, my lord.
Now, Brigadier, I want us to go back to the statement and I want to put certain questions to you. Before I do you still maintain the truthfulness of this statement?
Yes, I do, my lord.
Now, at paragraph 2, where it says, it initially appeared to be that it was a robbery gone wrong. Can you elaborate on that?
Yes, my lord. If one looks at the statement, then I think I dealt with this part, that when I was doing the analysis stage, but this analysis was based on what is contained on the docket. Statements of the people who were in the house are clearly indicating that the perpetrators, alleged perpetrators who came in, demanded cell phones and money. There was no indication, if you look in those statements, that there was an intention, there was a contractual arrangement to eliminate the deceased, my lord. It was an issue of a robbery that would have went wrong, and subsequently the deceased was shot. That assertion in paragraph 2, I base it on the facts that are contained in the statements disposed by the people who were inside the house, my lord.
And where it says 7 adults and 1 child were present in the house when the accused entered. In hindsight, now that we know, how many kids were in the house?
My lord, at the time I thought there was 1, but I do know that it was brought to my attention that there were 2 children. So the adults includes the deceased, but the children, which I did not confirm, but it was brought to my attention that there may have been another child belonging either to Ms. Kelly Kumalo. I'm not so sure, but there was make mention of a 2nd child, my lord. But personally, I have not independently confirmed that, my lord.
And then I read the sentence beneath that, which says the witnesses stated that one of the accused was carrying a firearm purporting to be a revolver. Which witnesses mentioned that one of the suspects possessed a revolver?
My lord, I may not recall their names, but they do indicate the witnesses, and I'll have to go through now the A1s if I must, so that I can specify. But the witnesses who were inside the house, they do indicate that the people were carrying some type of a revolver, a firearm with a wheel. And subsequently, there were statements taken by that investigating team to try and correct it, where people were also coming and saying they have no experience of identifying whether it's a revolver or not. So this is contained in the statement. So if I need to specify which witness, I'll have to go through their statements, my lord, but it is contained in the statements of the people that were inside the house.
Yeah.
Yes,
For the sake of brevity, Brigadier, I am absolutely interested in the witnesses that mentioned in their statements that they saw what a firearm that is a revolver. But I'm not going to make you go through all the A1s in this court now. I'll pack it and I'll do that as a homework for myself and yourself, so that when we come on Wednesday next week, we revisit this point. I'll also go and verify of all the people that were in the house except the deceased, who says they saw a revolver, because this is a pivotal point in this case.
Indeed, my lord, but I can say it without a shadow of a doubt, my lord. Even if the name revolver, and I agree with Mr. Ramosepele, let us do that. Even if the name revolver specifically may not have been used, but I'm not saying it was not used, I do recall without a shadow of a doubt that someone says it's a firearm with a wheel. Now, a firearm with a wheel is a revolver. I was trained in firearms, I know what it means, but I agree. Perhaps let us look into those statements and come and address the court accordingly.
And in supplementation of that homework that we are going to do, I may, in the meantime, refer you to Exhibit J, which is A46, which is a report by the facial image analyst, warrant officer Amanda Yvonne Steenkamp, who initially compiled the identity kits, which part of which form Exhibit BB, but I want us to go to Exhibit J.
Must we go there now?
Yes.
All right. Yes, I am on A46, my lord.
Okay. My lord, I'm not sure as well with this whether it was referred to in passing during the evidence in chief previously, or whether the contents thereof were actually placed on record. So I think, my lord, for the sake of completeness, I will also have to read the contents of this statement on record, and the specific aspect thereof that I'm concerned with is the witnesses that Warrant Officer Steenkamp worked with to compile this identity kit and the firearm that they described to Warrant Officer Steenkamp. And on the first page, which is this one, it simply says facial image analysis. Yes. And page 2 thereof, it says Fosleras CAS 636 of 10/2014, murder and robbery. And it says, I, Amanda Yvonne Steenkamp, do hereby state under oath that, and occupation and position in the South African Police. I am a warrant officer in the South African Police, force number, I won't mention it, stationed at the Facial Identification Unit at the LCRC in Pretoria, that is the local criminal record center in Pretoria, Protea Glen, where I am employed as a facial identification specialist with telephone number that I'm not gonna put on record. Qualifications and experience, I have 22 years service in the South African Police since 1991. I'm employed as a facial identification specialist at the South African Facial Identification Section since 1997. The functions I perform on a daily basis include the following: facial compilations, facial comparisons, and facial mappings, two-dimensional facial reconstructions of decomposed bodies and facial aging. I received training in the facial identification functions at the CRC, which I presume is the Criminal Record Center Training Section in Pretoria, and received facial identification specialist status during 1998. I received scarcity skills allowance for facial identification functions. I'm a facial identification section commander at Protea Glen Facial Identification Office. I am responsible for managing the section at Protea Glen. My responsibilities involve the managing of the section, 24-hour inspection, pocketbook, logbook, and case docket inspection of the member under my command. I compiled thousands of facial compilations, sketches, and two-dimensional reconstructions of decomposed faces, and since 2012, comparisons of on a daily basis. I gave lectures at training institutes to investigating officers and in-service training to new facial identification members. On the 11th of March 2014, I testified in an armed robbery case in Krugersdorp CAS 234 of 08 of 2012 and Randfontein CAS 348 of 08 2012. The accused, Olani Fihlani, was found guilty on the expert evidence in Protea Regional Court 7, CAS 43 of 1495 2013. And she goes on to put her training and qualification, which I'll read for record so that when she is called, this is not repeated. I also received the following relevant training within the South African Police. 1997, a 3 weeks training course in the facial identification field, interviewing and ID kit 2000 software and Adobe Photoshop. 1998, ISUS, that is ISUS, course, individuals, structures, activities, and extended research. 2008, an AFARC course, that is facial and cranial anatomy, that's what to do with the face, University of Pretoria, presented by Professor M. Stein. 2008, the facial identification workshop, in brackets, eFit, that is capital E and FIT, and Phantom and Composite Lab and Adobe Photoshop software, close brackets. 2010, the eFit software course, in brackets, presented by Dr. Chris Solomons, the Vision Metric Forensic Imaging, University of Kent in Scotland, close brackets. In 2010, the facial aging course, presented by Captain Brias, that is BRIERS, in brackets. In 2011, the basic police training at the Chatsworth Police Academy in KwaZulu-Natal. In 2012, the Advanced Facial Image Mapping and Comparison course hosted by the Forensic Anthropology Research Center at the Department of Anatomy, University of Pretoria, presented by Professor Caroline Wilkinson, that is WILKENSON, University, in brackets, of Dundee, Scotland. And then in 2013, the refresher course in craniofacial identification and facial comparison and photography, University of Pretoria, presented in brackets by Professor Stein, M. Stein. And then the paragraph 4 thereof, it still states the case number and her names, and she states under oath as follows. On Monday, the 24th of October on Monday, the 2014, 10/29, I was called out to Fosloras detectives accompanied by Lieutenant Colonel MJ Streicher, that is STREICHER, Operational Commander Proteadlen, LCRC, to interview witnesses in case 676-1024 Fosloras. I think that's a mistake there, but I read it as it is. Murder and armed robbery. I interviewed several witnesses individually. My first witness was Kelly Kumalo. Kelly told me in short that she and the deceased walked to the convenience store. Upon return, Kelly, deceased family member and friends had a smoke outside the house. Mrs. Kumalo called them inside to say goodbye. They sit down and start chatting again. Kelly was sitting near the kitchen when she saw two unknown African males entering the house. Suspect A, capital A in brackets, appeared. Entering. Kelly was sitting near the kitchen when she saw two unknown African males entering the house. Suspect capital A in brackets appeared very aggressive and demanded cell phones and money. This suspect was approached by Kelly and the deceased jumped up towards suspect A. A scuffle between suspect A and the deceased started. The next moment, Kelly heard two gunshots. She gave the following description. African male, in his 20s, dark brown shiny complexion, dreadlocks hairstyle, no scars, no facial hair, golden insert in upper teeth, language local Zulu. He was wearing a brown jacket with a woolen collar. He was not clean in appearance. Suspect A entered the house first. He was armed with an old black revolver. Kelly could not describe the second suspect. After compilation, she was satisfied with the ID kit. She compiled the face with the headgear. The second witness was Kelly's sister, Zandile Khumalo. She told a similar version and gave a similar profile and facial description of suspect A. The only feature she adds was the eyebrows. She saw the eyebrows when suspect A lost his headgear during the scuffling with the deceased. She could not describe the second suspect. The third suspect I interviewed was Tumelo Madlala. It's spelled with a TH, Tumelo Madlala, who was much traumatized. He saw the scuffling between suspect A and the deceased. After hearing the gunshots, he ran off to one of the rooms. He gave a similar description of suspect A. I showed him Kelly and her sister's compilation, and he was satisfied with the ID kit. He could not compile the second suspect. The fourth witness was Mr. L.S. Twale. He gave me a similar description of what happened on the scene. He saw a scuffling between suspect A and the deceased. After hearing the shots, he ran out to look for help. He could not describe the second suspect. At page 5, the fifth witness was Mr. T. Makeleni, residing at Mozamo 3942, compiled the face of suspect B. He saw 3 unknown males in the vicinity of a gas station busy on their cell phones. He saw them again at Kelly's mom's house. Suspect B stood at the gate. He gave the following description: African male, age 25 years, 1.8 meter tall, slender build, medium brown complexion, clothing a black hooded top. Witness saw a golden insert in the upper teeth. The hairstyle is dreadlocks. Facial hair is mustache and a beard. The witness saw something in his hand that could have been a firearm. Witness could not describe the rest of the faces. A sixth witness called Sipiwe, or Spe, it's spelled S-I-P-H-W-E, could not compile any faces, but he mentioned that he saw an old green/blue sedan near the danger box. 2 unknown African males were sitting in the car and the other 2 were standing outside the car. After a few minutes, the car left and only 3 unknown males stayed behind and were busy on their phones. The witness later saw them running. In front was a person with dreadlocks running with a firearm in his hand. The other suspect jumps over the wall. Lieutenant Colonel Streicher and I left Fostoras detective to see Mrs. Khumalo at her house. I interviewed Mrs. Khumalo at the neighbor's house. She gave a similar description of suspect A. I showed her the compilation and she said she saw a likeness in the face. She could not describe the other suspects, and it is commissioned and sold to by Amanda Steenkamp, commissioned by A.B. Haynes at Pretoria, at Protea Glen, at 10 on the 31st of October 2014. Now, Brigadier, the primary reason why I referred you to this statement, we were talking about the issue of the description of the firearm that some of the witnesses that were present in the house described to the police officers initially at the beginning of this investigation.
That is correct, my lord. And indeed, if one looks at the paragraph on A46, the interview with Ms. Kelly Khumalo, she does say it's an old revolver. But furthermore, my lord, during the lunchtime, I had an opportunity to peruse some of the statement, not completely, but I can say A9 by Mr. Longotwala, specifically paragraph 6, says it was a revolver. A9 paragraph 6, Longotwala. The same assertion, my lord, is also said by A10, Mr. Tumelo Madlala, in paragraph 5, where he says it's a 38 special when he described the firearm that he saw. Fine. But what is prudent, my lord, is that subsequent to this statement, there were further statements taken where some of these witnesses were then correcting what was contained, where they said they've got no experience with firearms, they could not have said that and all that and all that. But this is what was said initially at the beginning. Yes, my lord.
And to be fair to you as well, Tumelo Madala, when he was asked on this aspect, he says he could not have mentioned the word revolver or .38, but that the firearm that he observed was the one with the wheel. That's the rider or the proviso that he put when he testified in this court.
Well, my lord, I wasn't in court, but I've got no reason to doubt what Mr. Ramosepele is saying. But it will be difficult for me to comment on his evidence.
I will come back and converse with you at a much later stage, Exhibit J again, especially when it pertains to the identification of accused number 2, Mr. Ntanzi. Because from what I've read here, all of the people that were in the house, when they met Miss Amanda Steenkamp for the compilation of this report, they all stated to her that they could not identify the second suspect. And you can confirm that from what I've read from Exhibit J. Is that correct?
Yes, I can confirm what is written in Exhibit J, but Exhibit J, my lord, is the notes made by Warrant Officer Steenkamp.
Yes.
So to make the right context, one needs also to look at the statements made by the people who were inside the house, because they do give a description. Even if it's not accurate, they do, to the best of their ability, describe the first suspect and the second suspect. But I agree insofar as Exhibit J, but that it's basically an extract of what Warrant Officer Steenkamp was doing, but there are statements of the people who were in the house insofar as the description of the suspects.
And just for clarification purposes, still on Exhibit J, the witnesses T. Makeleni and the ones P. were, although it's incorrectly spelled, these were people that were not in the house at the Kumalo household on the 26th of October 2014. Is that correct?
That is correct, my lord.
Let's come to this aspect where you say, on it's paragraph 3, investigations revealed that the cell phone which was robbed was picked up through cell phone towers until the signal was lost, covering the area of Fostora's hostel.
Yes, my lord.
At the time you deposed to this affidavit A225,
yes,
were you also in possession of the cell phone records, both of the people that were in the house and some of the people that are suspects or now accused in this matter?
Yes, I had the cell phone record. That's correct, my lord. But I was also guided by the cell phone analyst at that time, because Kenneth Stein was already on board and he had already disposed affidavits. And I do recall that I also made a site visit of where this Muleleki Tower is situated.
Okay. Now you saying, and correct me if I'm wrong, according to your information, Muleleki Tower services, you say a hostel in Fostoras. Which hostel are we referring to?
My lord, I was referring to Basutino Hostel, and as I said again, my lord, these expertise were based on the knowledge or the expect information that was given to me by Kenneth Stein. But like I said, also the site visit for myself to see where exactly this tower. It is not far from the hostel, meaning now the scene where the alleged meeting took place before the killing of the deceased and after. It's just across the road, between Fostoras and when you go towards Cattle Home. So that's the explanation that it gave to me to say this tower can cover that hostel in terms of the distance. But it was not to say, my lord, on that specific day. The assertion that I'm making is not to say that on that specific day, this tower, when the signal was sent, it was active and covering that, but it was say the range. That's the explanation Kenneth Stein told me, that the distance could cover the hostel. That was my understanding.
Brigadier, to be fair to you, and I requested time on Monday to go and revisit all of the evidence that has been covered thus far. And I don't want to put a wrong proposition to you. So this aspect of you saying Moleleki Tower covers the range of the Basotweni hostel, I've got a different understanding, but I want to verify that from Ms. Vitilingam's evidence before I put it as a proposition to you. So I'll also mark it as one of the aspects that I will pack.
Yes, it is fine, my lord. But the context that I'm saying, and I want to repeat, my lord, is said the distance where the tower was and where the Basotweni hostel, and that's my recollection of the explanation by Kenya State, could cover that hostel in terms of the distance. What it did not say to me is that on that specific day, that tower was active. All he told me is that this is a tower that picked up the cell phone Muleleki section, and I wanted to know where is this tower in relation to where the meeting took place. And obviously my next question is that could it cover this place in terms of distance? And the answer was yes.
And then you also mentioned that the investigation which resulted in evidence under oath revealed that the victim was murdered as a contractual assassination or hit rather than a robbery or robbery gone wrong. Can you elaborate on that, and what statements and evidence did you rely on to come to make such an assertion?
Yes, my lord. I think one statement that comes from the top of my mind is the one of Kwabendi, Sifiso Zungu. It guided me to that effect because he places the 5 accused, and I think it talks to that issue of contextual killing. There are other statements, my lord, which may be involving not collectively but some of the accused, individual. For example, accused 3 and 4, where almost similar assertions are made. So there are different statements in the docket, and I can be specific, my lord, if that is needed. But one of them, like I said, it's Sifiso Zungu.
Okay, sorry, Brigadier, just to come back to Exhibit J, just one point. I forgot to ask you, this, the 5th witness to Ms. Tenkamp's ID kit compilation, Mr. T. Makeleni.
Yes.
What is his status? Is he still alive or is he a deceased person?
No, he's a deceased person, my lord, currently. We also obtained, I think, his death certificate. He passed on, unfortunately, before this trial commenced.
And then further you say, evidence under oath revealed that 6 suspects actively participated in the planning and execution of the contractual murder of Senzo Meyiwa at the directive of Kelly Kumalo. Currently we have, before standing and sitting before this court, 5 accused persons, and in the statement it says 6 suspects actively participated in the planning and execution. Who is the 6th suspect?
It's Ms. Kelly Kumalo, my lord. Remember this statement, I was applying for the warrant of arrest for Ms. Kelly Kumalo, so she would have been the 6th suspect. This one, at that time, were already arraigned. They'd already made their first appearance, so this was November. So I was now moving towards Ms. Kelly Kumalo to be added, so she was the 6th suspect.
And on page, the next page, or at the top, you say this suspect, Nontlantla Kelly Kumalo in brackets, is first linked by means of confessions that were made by both accused 1 and 2. Let me pause it here. On this aspect, further down in my cross-examination, I'm going to touch specifically on the confession statements, exhibits HH and JJ, allegedly made by accused number 2. So this point I'll pack it now and then move it forward. It says investigations further revealed that she had 4 other cell phones that she did not disclose to the police when the incident took place, and then the numbers are the ones that I mentioned. Now, what was the relevance of saying she had these other 4 cell phones that she did not reveal? The significance thereof for you to put it in this statement?
Indeed. No, so the relevance of it, my lord, one will recall that if one reads the exhibits, the confessions made by accused 1 and 2, somewhere in the confessions there is appearances where it is alleged that accused 3 was communicating with, sometimes they call her sisters and so forth. It's what is alleged there, my lord. And these sisters is being referred as Kelly Kumalo. Now, when one took the cell phone records, that the section 205 that were done on the 2 numbers that were known at the time, this is now the runaway phone that picked up the tower from the Lekki section, and the 082 number that was not taken. There is no communication there that you can find in an open thing except the downloads in the 082 number. But even that downloads, my lord, that links accused number 5 does not is not happening on the day of the incident. In other words, the other one happened on the 2nd of August, the other one is the 15th of October. That is now prior to the commission of this offense. The relevance of me mentioning this thing is that seeing that there were these numbers that were in a possession and active, it is a possibility that this assertion that there was this communication was lying in those numbers that were not known to the police at the time. By the time we came to know about them, the window period to get the communication of 3 years had lapsed, and we could not get a device to actually do the downloading. So that is the relevance of mentioning these numbers. But furthermore, my lord, what is important or prudent to mention is that this transpired during the collaboration process. As I said, statements are made, confessions needed to be collaborated. So this assertion that it is alleged that there was this communication between accused 3 and Ms. Kulukumalo was missing in terms of the date, because it's being said that it was happening on the day of the offense. So it was, something that one needed to know. But how could it be? Because we do have the cell phone records of Ms. Kulukumalo, the 2 cell phones, and that seems not to be there. And that is how now the cell phone expert Kenneth Stein was able to establish and link these phone numbers, that these numbers belongs to her, they were active and they were not disclosed to the police at the time.
Okunye futhi okusemqoka-ke ukuthi nanjengoba kukhona le nkulumo ukuthi kwakuxhumana kwakukhona-ke phakathi kwakhe-ke uMs Kulukumalo kanye naye-ke umsolo wesithathu-ke sinawo-ke lama-number noma-ke lama-cellphone amabili-ke, kodwa-ke lokhu akutholakali-ke. Manje kwakusemqoka ngalokho ukuthi-ke manje uKenneth Stein okuyena-ke komcwaningi wabomakhalekhukhwini useyasho ukuthi-ke manje-ke khona-ke nalama-number lana usengabhekwa kuwona-ke ukuthi uzotholakala yini ukuthi kwakungokuxhumana.
Yes.
Now, Kenneth Stein deposed to Exhibit 01 and 02, which at the moment I don't have them in front of me. But amongst other things, he listed about 8 numbers, including landlines, that Kulukumalo used at the time, and as to each number, when she started using the number and when the period of using that number ended. The question then becomes, of these 4 numbers, did you determine if Kulukumalo was using 6 cell phones on the night in question? That is, these 4 numbers, the 082 number and the 2498 number. Was she using 6 cell numbers on the 26th of October 2014?
Yes, that's the understanding I got, my lord. So one will recall that what she disclosed to the police, it's the runaway phone, the phone that was never recovered, and the phone that was downloaded, where the linkage with the alleged phone of accused 5 was picked up. So that was disclosed, it's in the docket, the numbers are listed. These 4 that I'm referring to, it's what the analyst found, that they were active, but they were not made available to the police. Hence, there's no section 205s that were done at the time, and there was no downloadings done on those numbers. And I'm saying this, my lord, also perhaps to put it in the right context, is that at the time when I made this application for the arrest of Ms. Kulukumalo, that was the information available to me from Kenneth Stein. But subsequent to that, it was an ongoing analysis that he was embarking on. So it is not surprising that, as Mr. Ramosepele, that in other statements, the numbers are more, because it was an ongoing investigation. Particularly, my lord, I'm saying this investigation towards Ms. Kulukumalo, because one will remember I've indicated that before the 5 accused were processed and brought before court, there was a desire, based on the information that we had, to add Ms. Kulukumalo, but it was clear during our discussion with our colleagues that more investigation needed to be done. Now, it then takes us to the statement of November that Mr. Ramosepele refers to, and then subsequent to that, obviously engaging with the NPA, there was also a desire that we need to collect more. Hence, you will see the numbers increasing and all other things that came up that we even didn't discuss and that we did not even cover in this court because it's not relevant at this stage, my lord.
When did the police, the investigative team, discover these 4 numbers?
It will be prior to me making that statement, my lord. I will have to go through the docket to establish, but they were discovered by Kenneth Stein, as I said. So it was after the confessions were made, because it is after the confessions were made where it was now becoming, or this assertion was made, that Ms. Kulukumalo, it's alleged that he gave the instructions and there was a communication. So the desire to establish or to find that communication started there. And it would have been around that period where Kenneth Stein then discovered these numbers in trying to collaborate over what was contained in the statement, and that statement would have been made after that.
Because Brigadier, sorry, my understanding from the evidence of Colonel Steyn, and to some extent your evidence, is that your team did not go about and do new Section 205s for the people that were in the house. That Section 205 was obtained by the previous investigative team, and when you got on board, it's then that Colonel Steyn worked per your instructions on the Section 205s of the people that were in the house.
That is correct, my lord. As I've said, my lord, the Section 205s that were made for the people who were inside the house were made by Captain Bomsram.
Yes, but the point that I'm trying to raise is the following. These numbers in terms of the Section 205s, even if Colonel Steyn discovered in 2020 that there were these numbers could have been available to the previous investigative team from the Section 205s of 2014 that were requested by Colonel or Warrant Officer Bostra. I don't know his position.
No, not exactly, my lord. So the investigating officers at that time, they did Section 205 based on the numbers that were given to them, that were contained in the statement. These 4 numbers were not disclosed to them, so they did not know they exist.
And now let's go to this one. Investigations further revealed that she is linked to the actual perpetrators of the murder by means of cell phone linkages. These linkages connect her to accused 3 and accused 5. What do you mean by cell phone linkages?
Well, my lord, I'm referring to, accused 5, for example, I think we've dealt with the 2 calls. Accused 3, we dealt with the bag, the see-through bag, which appears on accused 3's phone, and that's a link, and Miss Kelly Kumalo. But as I said, my lord, and to be fair, unless then Advocate Minister does not mind, then I will go into it, because there are certain things that we found that links Miss Kelly Kumalo, but for the purpose of this court, we didn't bring it up because it's not relevant. Yes. So that is the link that I'm talking about. So if I'm asked to go deep, but unfortunately it will have a bearing on Advocate Ministers.
No, I don't want us to go to, I'm just reading the statement as is, and I was asking, by cell phone link, what do you mean? Is it media that is contained in the phone? Is it calls? Is it text? But I've got my answer. I don't want you to go to another advocate's evidence.
Wait, I don't understand. You're asking a question. You're obliged to answer the question pertaining to your investigation.
Yes, ma'am.
As you conducted it, so that the court can appreciate too. You can't tell me that you disclose this piece of evidence, but you won't disclose this piece of evidence. What should I do about the rest of your evidence then?
Understood, my lord. My lord, so the other aspect that I didn't touch on is that there is the report that I got, and is contained in one of Colonel Steyn's statements. There is a link between, let me say, communication between Miss Kelly Kumalo and accused 3. In a nutshell, I just don't know how Colonel Steyn phrase it, but he established a link between accused 3 and Kelly Kumalo, other than accused 5.
Now let's go to.
Basically, the court, madam. Yeah. This is not an objection, it's just a clarification. So the information that I need to understand and follow it. So what Brigadier Gininda is saying, the further information that is not disclosed to the court as per the court's concern is that the statement of Steyn actually says that there was a link between accused number 3 and Kelly Kumalo. That's the information that it did not disclose to court, according to him. I just want to follow that statement.
Are you able to explain, sir?
Yes, my lord. What I can explain is that the statement that I saw, and if it needs be, we can get to it and I can read it verbatim. There is the statement of Colonel Steyn links accused 3 with Miss Kelly Kumalo. That's the essence of it. As to how we put his terms, that's the part that I don't want to misquote him. But what is clear is that there's a link with Miss Kelly Kumalo and accused 3.
Yeah, but what is of concern to this court is, was that statement discovered?
Yes, my lord. It's the statement
to the defense also.
Yes, it's a statement that was attached in the document.
Wait. Let's understand each other. Take it slow. Because if you haven't discovered that information, you can't use it now. But the law allows you, if you have discovered all the information you are testifying about,
yes, my lord,
and you are able to say it was discovered, this is the information. But if you're not able to say that, I can't take that information. Are you with me?
I'm with you, my lord. What I know, my lord, the state statement was signed, attached in the docket, and it was disclosed. Whatever that is in the docket, in the X section, was disclosed to the defense. So it's not something that we kept away. It's in the docket, and it was disclosed, my lord.
Now, Brigadier, let's go to the specific linkage that you talked about even in your evidence in chief, which is the transparent plastic with money in it, which you said from the downloads of accused number 3, the downloads of Longwetwala, and the downloads of Kelly Kumalo, that photo is a common denominator. Is that correct?
That is correct, my lord.
As a lead investigator in this case, did you present and confront Kelly Kumalo about that photo and seek an explanation from her?
No, I did not, my lord. Remember the court, I've said, my lord, she was a person that we were intending to charge together with this accused. So the time when I would have approached her and obviously put these assertions would have been when I went to take a warning statement and process accordingly. There was enough in my view, based on what we had, to apply for the warrant of arrest. And obviously, as the process, that's a normal process. Before a person appears, we'd have sat down with that person, interviewed that person, and these assertions would have been put, my lord. So at that stage, I didn't, but it was evidence that was important for me to mention in pursuance of the J50, in other words, the authorization from the NPA to be granted. But furthermore, my lord, one will also recall that I've indicated that it was a prosecutorial driven investigation. So we're discussing, with the state advocate to say, can we approach the timing? So those things, you don't do it in isolation. So there was no blessing to say, go ahead and interview her on these aspects.
Did you determine from either cell phone records or from the experts within this field that were assisting the police, the investigation, the source of this photograph with depicting bag of money, a transparent bag of money?
No, my lord. I know. I don't want to misquote them, my lord, but no, I don't recall them, my lord.
And the link of that photograph, did you determine who shared with whom amongst the three? Did they share amongst the three, or the source of origin from the individual phone, Longwetwala, accused number 3, Kelly Kumalo, as to the source of that photo?
My lord, I think in the statement is contained. So that is a terrain which is an expect evidence, and I don't want, but I think the Colonel Stein explains whether it was shared or taken by, so I didn't focus, I'm not an expert, my lord, so I don't want, and I didn't even cover it on my statement because I think that's the area that I don't have the expertise, except to say, I was convinced that these photos appears because I was shown the downloads, but all those technicalities, I don't have the expertise, my lord, but except to say, I know it was there in those 3 downloads.
Yeah, sorry, but for my own understanding, these are photos of 3 individual different persons.
Correct, my lord.
They don't stay together in the same house.
Absolutely correct.
Are they friends?
No, I didn't find
Are they
evidence.
acquaintances?
I didn't find such evidence.
Is the relationship between the 3 of them, like, for instance, Zandile told us his boyfriend, sorry to use that language, is Longwe, for instance. Are you with me?
I'm with you, my lord. In my investigation, I didn't find such a relationship, and that is why in the very same statement Ramosepele is referring me to, I do indicate somewhere that for me it was concerning as to why Ms. Kelly Kumalo in particular will be talking to the hitmen or the people alleged to have killed her boyfriend, because I could not establish any relationship that will justify the communication.
Did you confront Longwetwala about this photo, show it to him, and seek an explanation from him regarding the presence of this photo in his phone, in his phone's memory?
No, sorry to speak over you, Mr. Ramosepele. No, I did not. Same reasons, my lord, that concern me, because you find there are people who are alleged to be the perpetrators of this offense, and in their device you find a common denominator, which is now found in Longwetwala. Now, it changes the view, and one needed obviously to tread carefully and be guided by prosecution as to when do we approach him. So we didn't approach him, but it was based on serious concerns that we had about this common denominator that is found in accused three's phones, and mysteriously then it appears in the phones of Mr. Longethwala and Kelukumalo. So in essence, my lord, one of the reasons that made us not to approach him, it was serious concerns which may be similar to the ones that were motivating the non-approach to Ms. Kelukumalo with regard to Mr. Longethwala.
And accused number 3 is arrested on this matter. Measurements are taken from him. Scars are checked to determine whether he had scars from this. Did you also confront him about this picture of a plastic bag with money and seek an explanation from him regarding that?
I know, my lord, I confronted him with the allegation containing to this matter in totality, and he responded, but the response was not...
No, I'm so sorry, Brigadier, to cut you. I'm speaking specifically about the plastic bag with money, not the totality of the evidence. That's way out of the specific confine of my question.
Yes, but that's what I'm trying to answer, my lord. So the bag of money is in relation to this matter. It's not a standalone matter. So when you interview a person, it's a collective. You put the allegation. So in the warning statement that I took from him was a warning statement regarding this allegation, and there were obvious responses that he gave me, but we didn't deal with the warning statements during the trial, within trial. I'm not sure now whether I should go to what is...
No, I didn't ask you about that.
Oh, okay.